Come back. This is Upfront, the Wednesday afternoon edition. Now, the Supreme Court of Appeal has declared unconstitutional the hate speech provision contained in the, wait for it, Promotion of Equality and Prevention of Unfair Discrimination Act. The short name of it, of course, is PEPUDA, or the Equality Act. This relates to the case involving Jon Qwelane and the South African Human Rights Commission. To help us make sense of why some provisions of PEPUDA are regarded as difficult to understand is constitutional law expert, Professor Michael Osborne from the University of Cape Town. Thank you, Prof, for joining me. So, in essence, this has to do with Section 10 of the PEPUDA, the Equality Act, and basically the allegation and the finding, at least, of the Supreme Court is that it's overly vague in the way that it defines what can be termed hate speech. This is not a new debate, is it?
No, it's not a new debate. Good afternoon to you. It's not a new debate in the sense that there have been a couple of cases in the lower courts in which judges have struggled to make sense of parts of Section 10 of the Equality Act because, frankly, they're poorly drafted, and it's very difficult either for ordinary people, for their lawyers, or for judges to understand exactly what the intention of the legislature was as to precisely how hate speech would be defined.
So this has to do with the wording there, if I understood correctly, that includes that the words spoken and the kind of speech that is in question can be reasonably construed to constitute, to demonstrate a clear intention to be hurtful, harmful, and to propagate hatred. What's difficult about this phrasing that says reasonably construed?
Well, you've got to read the whole thing as a single provision and in context. Now, the concept that hate speech would be that which propagates hatred or is harmful, that's not problematic. What is narrowly problematic is the definition of hate speech as that which a reasonable person might construe as being hurtful. And the problem that the Supreme Court had was that hurtfulness is a subjective state of mind, as it were. What's hurtful to one person may not be hurtful to another. The court made the point that much of our political discourse, being robust and energetic, may indeed be hurtful in its content and to certain people. The point then is that you cannot punish people under a statute or hold them subject to the Equality Act by virtue of a standard that's as open-ended, vague and overbroad as the subjective feeling of hurtfulness that some people may or may not feel.
So then the Supreme Court of Appeal goes on to give a sort of interim rewording, a read-in of the Section 10 as they would want it to be encapsulated in whatever amendment that the legislature, that Parliament brings in. Interestingly, in what they do then, in moving away from, this reasonably construed to institute and demonstrate intention to be harmful, hurtful, they now introduce the whole question of no person may advocate hatred that is based on race, ethnicity, gender, etc. So in a way, they bring it back to align it to Section 16 of the Constitution?
Yes, that's quite right. It's supposed to be a hate speech provision, and it's supposed to be consistent with Section 16, that is the free expression clause of the Constitution. And in order to fit it into that constitutional space, you've got to take away or subtract the subjective element of hurtfulness and replace it with something which, at least in principle, is easier to determine and is less of a restriction on the scope of speech in this country, be it political speech, cultural speech, or everyday discourse. So now what the prosecution, or I'm sorry, in this case not the prosecution but the Human Rights Commission, in principle would have to show is that this is the kind of speech which reasonably interpreted may in fact cause harm, which the court made clear may be physical or psychological harm, or will constitute hate speech.
Right.
The concept of hurtfulness for now is out the window.
So finally then, Prof, thinking about this case going to the Constitutional Court for confirmation of this order of invalidity, how are you weighing it up? Because interestingly, I was listening to Professor Pierre Defosse talking a bit earlier on about, you know, these provisions of the Equality Act have never really been tested at that level at the Apex Court. What's your sense? Are we likely to get even further clarity whether or not that speech and the pronouncements of a person actually need that added element of incitement to cause harm for them to constitute hate speech?
Yes, as you mentioned, the Supreme Court of Appeal may not in itself and finally strike down an act of Parliament. Their decision that that part of the Equality Act must be struck down is always subject to the highest court, that is the Constitutional Court. So there's, as it were, an automatic confirmation protocol. Now, I've got no doubt that the Constitutional Court will give some much necessary guidance. It may follow the same track as the Supreme Court of Appeal, or it may say that, in fact, in context and in light of precedent, hurtfulness is indeed a sufficiently or provides sufficient guidance. It has many options. What's good is that indeed this has never gone to the Constitutional Court, the particular issue of the constitutionality of the Equality Act. So we look forward with some anticipation regarding what the Constitutional Court is finally going to say about this.
All right. Thank you so much for your time and your insights there. And that's Michael Osborne from the University of Cape Town.